Today is 264th Friday group meeting. The topic is impeachment of judges, shortfalls and suggestions. The speaker is Mr. Ramakrishnan Viraraghavan, Senior Advocate and Barrister. Sir also addressed our Friday group on 13/10/2023. The topic was Constitution of India, Principles of Interpretation. That was the 192nd Friday group meeting. Thank you very much, sir. At least we are happy. Finally, we got it. One second. Side.
Okay, sir.
It's okay. Perfect, sir.
Volume is okay? Thank you very much, and thank you for waiting again. This is on impeachment of judges, shortfalls and suggestion. It is a timely topic, but I will not take names as far as possible. We will concentrate on the law. The Constitution does not talk of impeachment of judges, doesn't. The constitutional provision, Article 124, talks of removal of judges from office. Impeachment is a word used for other high officers like the President of India. I will read this section, Article 124, and that sub-Article 4 talks of impeachment of Supreme Court judges. A judge of a Supreme Court shall not be removed from his office except by an order of the President, passed after an address by each House of Parliament, supported by a majority of total membership of that House and by a majority of not less than 2/3 of the members of the House present and voting, has been presented to the President in the same session for such removal on the ground of proved misbehavior or incapacity. Sub-Article 5. Parliament may by law regulate the procedure for presentation of an address and for investigation and proof of the misbehavior or incapacity of a judge under Clause 4. The separate Article 217 for removal of office of High Court judges refers to this, and this is the basic provision. If you split this into easier language, first, removal is on the ground of proved misbehavior or incapacity, only two grounds. Removal must be by an address by each House of Parliament, Rajya Sabha, Lok Sabha. It must be supported by two different kinds of majority. Number one, address should have the support of a majority in number. So how many majority in number, again, is open for interpretation. It is not the total number of seats available, total number of people available occupying those seats. That's the total membership of that House. And the second majority of 2/3, not less than 2/3 of the membership of the House present and voting. Next, the address must be presented to the President in the same session as it is passed. And third, it must be followed by a presidential order for removal. What is the purpose of this? We talk of the most powerful office under our Constitution. Most powerful office is that of the Prime Minister. Prime Minister has no such procedure for removal. He can be removed by one vote, one majority vote. It's nothing new, it has happened before. He has a fixed tenure of 5 years as a member of the Lok Sabha, not as Prime Minister. Prime Minister, his tenure depends only on the confidence of the House, which can go after a year, after a month, after a week. Now, why is there no procedure for removal of the most powerful office under the Constitution, which can be most abused also? But why is there for this? Now, you go back to 1600s for finding out the reason why this is happening. In 1600s, in England and Wales, judges used to be appointed at the pleasure of the king. That had its own drawback. When there were cases in which the king was interested, he expected the judge to obey him. Otherwise, he would remove the judge. Removal of judges was so easy. All that the king had to do, he was appointed, a judge was appointed by a warrant of appointment by the sovereign. Another warrant of removal, he is removed. In the Act of Settlement of 1688, there was a tenure imposed for the appointment of judges, fixed tenure, and the removal was subject to good behavior. We borrowed that in our constitution, and if you refer to various other constitutions, including the international standards of appointment of judges, there is an international standard of appointment of removal of judges, the United Nations Basic Principles on the Independence of Judiciary. It incorporates provisions on tenure, discipline, and removal. It says conditions of service, tenure, it should be adequate till the rate of retirement secured adequately by law. Then judges, whether appointed or elected, shall have a guaranteed tenure until the mandatory retirement age. You can't remove them saying 5 years, 6 years, which is unfortunately happening with your tribunal judges. Discipline, suspension and removal. A charge or complaint made against a judge in his or her judicial professional capacity shall be proceeded expeditiously and fairly under an appropriate procedure. The judge shall have the right to a fair hearing. The examination of the matter at its initial stage shall be kept confidential unless otherwise requested by the judge. Decisions in disciplinary, suspension or removal proceedings should be subject to independent review. The principle may not apply to decisions of the highest courts and those of the legislature in impeachment or similar proceedings. So, basic principles of the UN is security of tenure, right of justice, right of natural justice, fair procedure for removal, independent scrutiny. This will not apply to legislative procedure for removal. Going by the international standards and by the practice in England after the Act of Settlement, impeachment proceedings are actually not proceedings for removal of judges. They are actually proceedings for prevention of removal of judges. They have made it as difficult as possible. In England from 1688 up to recently, only one judge has been removed in 300 years, only one. And that judge was not an English judge, he was an Irish judge. So they didn't want to remove their own. Now here, 70 years, not a single impeachment. So the article has fulfilled its purpose in one sense. It has guaranteed tenure and security of office to the judge. And why is this so? I'm going to the other end. What is every litigant's dream? Every litigant's dream is to have the judge on his side. Every litigant. I'm not talking of corruption. I want the judge on my side. And who is the biggest litigant in the country? The government. So the government is always interested in having judges on their side. Not in one case, not for cash and carry, but in every case they want the judges on their side. And one way to ensure judges on their side is what the king did. Either you appoint judges whom you like and who like you, or you get rid of judges whom you don't like. Only two things. The problem in appointment and the problem in removal is found in every jurisdiction, every common law jurisdiction, every jurisdiction which has an independent judiciary. There's a famous American president immediately after the World War, and Roosevelt, FDR. He said during his long tenure he made two mistakes. And he said both mistakes are sitting in the Supreme Court. So the appointment of that judge, he felt, those judges, he felt was a mistake that he did because he couldn't do anything. They are lifelong judges there. But every jurisdiction says misconduct, and there should be a very difficult process. I'm talking of comparison of various courts, various jurisdictions. United States of America, majority of the House, Senate, 2/3 majority. And the reason is conviction of treason, bribery, high crimes, and misdemeanor. Ireland, misbehavior or incapacity, same as ours, because we borrowed heavily from the Irish Constitution. Canada, resolution of both houses. Ireland, simple majority. Age, infirmity, misconduct, failure due to execution of office, position incompatible with due execution. Singapore, misbehavior, incapacity. Australia, misbehavior, incapacity. So independence of judiciary is secured by ensuring almost an impossible procedure for their removal. Then we come to the difficulties which we have faced. Justice Syed Imam, very distinguished judge, Syed Jafar Imam, barrister at law, finished his school in Oxford, LLB in Trinity College, Cambridge, bar at Middle Temple, Chief Justice of Patna, then Supreme Court. Appointed to the Supreme Court in 1955, he was to retire in 64-65. Look at the tenure. He had very long tenure then. Unfortunately, somewhere around 63-62, he had a stroke. He survived, but incapacity. He couldn't really function as a judge. Despite his incapacity, he did not resign. And on 31st of January 1964, a crisis came in. The previous Chief Justice was remitting office. He was J1. Next, seniority, and then there was another senior judge. Pandit Jawaharlal Nehru wanted to follow seniority in appointing Chief Justices. Then the Supreme Court judge, one of the Supreme Court judges of the Chief Justice, he said, let us follow seniority, appoint Justice Imam as the next CJI. Only one test. Please ask him to say Indian Constitution. I will be sitting, you ask him to say Indian Constitution. If he says Indian Constitution, make him the Chief Justice. He could not speak. He was suffering from a stroke. He could never say Indian Constitution. But he did not resign. And people didn't know what to do because till 1964, Article 5, Sub-Article 5, Parliament may by law regulate the procedure for the presentation of an address, investigation and proof of misbehavior and incapacity of a judge. That was never done because the occasion never arose. 1964, the bill was introduced and he was said, look, we are introducing a bill in the Parliament and you will probably be the first one in that bill for incapacity. He resigned. He resigned on 31st January in the forenoon. The earlier Chief Justice had resigned a little early, demitted office on retirement, and the J2 became the Chief Justice. The history behind, this is a history behind the Judges Enquiry Provisions Act. And now you go on to the Enquiry and the provisions of the Enquiry Act. It's a very simple act. Judges Enquiry Act 1968. Now after he resigned, that urgency was no longer there, so the act took about 4 years to pass. And this is a very short act. 7 sections, definitions, investigation into misbehavior or incapacity by a committee, and the report of the committee, powers of the committee. These are the things. First thing is, it says, Section 3, I would like you to read Section 3 with Article 124(4). It says, supported by an address by both each House of Parliament. Section 3 says, how many and how is that address to be given? Section 3 is the starting point. If a notice is given of a motion for presenting an address to the President praying for removal of a judge signed in the case of Lok Sabha 100 members, Rajya Sabha 50 members, then the Speaker or the Chairman of the Council will think whether to admit the motion or not. So here you have again a problem. First thing is, which comes first? That has also been provided. Whichever house the motion comes first and it's admitted first will have the say in appointing the committee. If both come at the same time, then there will be a joint committee to be constituted by the Speaker and by the Chairman. There may be an instance when a notice comes to a particular house and the Chairman says, I will not admit it. Or the Chairman delays admission by 2-3 days just to make sure that the Lok Sabha Speaker gets the chance to admit, or the other way around. What happens if the motion is denied? There are grounds, members believe so, newspapers are full of these, but the Speaker or the Chairman, is that justiciable? I think it is justiciable, but this happened earlier. This happened earlier when one of the Chief Justices was alleged to be handpicking judges for sensitive cases. So court packing was done ostensibly by the Chief Justice and an impeachment motion was given. The Vice President, Chairman of the House, he refused to admit it. He just said, I am not admitting it. He said, we cannot allow any of our pillars of governance to be weakened by any thought, word or action. Very rhetorical, but he said, I won't admit it. Then one of the MPs filed a petition here, and that is a judgment of Pratap Singh Baba against the Chairman Rajya Sabha, 8th May 2018, bench of 5 judges, usual. After hearing arguments for some time, petitioner seeks to withdraw the petition. So that was the end of it. No law was laid down. But is it justiciable? That's one question. Is it justiciable if two issues may happen? One, the address says these are the acts of misconduct or incapacity, and that's signed by 50 or 100 MPs. Chairman or Speaker refuses to admit it. Is it justiciable? Other way around, it is admitted, then is it justiciable? It may be a witch hunt to bring disrepute to a very honest judge who is against the government or against the parliament. Deliberately admitted, is it justiciable? My own, not yet come in for legal research, and when you go into the Constitution Assembly CAD debate, there is nothing on this. They simply borrowed it from past precedents. They discussed so much about so many other things. They did not think this will happen. They had probably great confidence that the deterrent of an impeachment would be enough to keep judges straight and narrow. So if the Chairman or Speaker deliberately refuses, I think it's justiciable. Maybe he should allow the matter to proceed. Then another difficulty emerged. I'm an author, so I like this story. Chief Justice of Bombay, he had written 2 books, one on Hindu law, one on Muslim law. This is 1995. A publisher in London agreed to purchase his book, royalty of $80,000 for one book, $75,000 for another book. I calculated 1995 rates, 25-30 lakhs per book. I've written 3 books, 2024, 2025. If I had 1/10 of that, I'd have been a very, very happy man. When this news came out, the Bombay Bar passed resolutions saying there's something seriously wrong, he must resign. You can't have this. And there was enormous pressure on the judge. A litigation was filed in the Supreme Court direct. C. Ravichandran Iyer versus Justice Bhattacharya, 1995, 5 SCC 455. And the relief there is, refer to CBI, do whatever you want, but don't allow these lawyers and bar associations to pressurize a judge to resign. By the time it came up for hearing, the pressure worked and the judge resigned from office. But the facts were taken up and the matter was heard by this judge. I think it was a two-judge bench, Justice K. Ramaswamy and Justice Hansaria. They made an interesting discussion. They said the words used in 124(4) are proved misbehavior or incapacity, not defined anywhere. What is misbehavior? Is misbehavior different from misconduct, or does misbehavior mean bad behavior? And the court said every act or conduct or even error of judgment or negligent acts by higher judiciary by itself does not amount to misbehavior. Willful abuse of judicial office, willful misconduct in office, corruption, lack of integrity, or any other offence involving moral turpitude would be misbehavior. Misconduct implies actuation of some degree of mens rea by the doer. Judicial finding of guilt of grave crime is misconduct. Persistent failure to perform judicial duties of the judge or willful abuse of office, dolus malus, will be misbehavior. Misbehavior would extend to conduct of the judge beyond the execution of judicial office. Then they were deciding on what happens to bad behavior. Various kinds of behavior would be utterly bad, but they would require correction of a judge, not necessarily removal from office. Now, removal from office by impeachment for every small behavior is like having the IPC listing various offences, but only one punishment, capital punishment. Any offence, you have the same punishment. That is not workable. Question arose, how do you handle bad behavior which does not amount to misconduct or incapacity? Various kinds of bad behavior, being extremely rude. There is a gender bias on the bench, casteism, heaven knows, so many other things. Or again, there is something by Justice Venkatramaya. Justice Venkatramaya, you see, the exit interviews of judges are very interesting. All the feelings they have bottled up throughout their tenure, they pour out at the exit interview. Chief Justice Venkatramaya, E.S. Venkatramaya's exit interview, he said, in every high court, Justice Venkatramaya judges to be around 90 and favors transferring them to other high courts. There are allegations that certain judgments have been influenced. The result of this interview was contempt petition against him by the Bombay High Court. Nothing much happened to it. But if I'm winding and dining at every lawyer's house, that may not be per se misconduct or incapacity. If the next day there was a Supreme Court judge recently retired who told me about this anecdote when he was a puisne judge. He said the Chief Justice of his High Court and this lawyer who hosted the party were laughing riotously and absolutely drinking till the wee hours of the morning. And he was sitting with the Chief Justice the next day. Third or fourth admission was this lawyer. He said that lawyer wasn't very sober, nor was the Chief Justice very sober. It was the next day. They were all slightly recovering. But he said the Chief Justice was so very harsh on the petitioner, not on the advocate, harsh on the petitioner. Tore him to pieces and dismissed the petition. What happened at the party was completely forgotten by everybody. And then this judge who was telling me, he said, that is independence of judiciary. You can't be a monk. You go out for parties, meet friends, come over, but that's for that particular judge. But the judge which the former Chief Justice said, that may be bad conduct. And how do you address bad conduct? Article 124 does not cover bad conduct at all. Zero. What is a solution? One of the solutions was given by the Chief Justice Kaufman, U.S. Court of Appeals for the Second Circuit. He wrote an article in the Yale Law Journal. This was in 1978-70. He said, you can't allow bureaucrats, lawyers or others to determine the fate of judges. That will have a chilling effect. Judges' fates should be determined by the judges themselves. The sheer magnitude of this disciplinary proceedings will again be a deterrent, and there will be a chilling effect on judges, because this was very particular to the Madras High Court about 15 years ago. And again, one of the judges who recently demitted from the Supreme Court, he said for Madras High Court alone, every proposal for appointment will have at least 20 anonymous letters. He says if that ratio comes down, which means people don't know you, that is all. Not that. So, every judge, every potential judge faces so many. Then how do you regulate the judge's conduct for bad behavior without holding the stick and without discouraging him? If you discourage a judge very much, judges are human beings, they will think the best way I can do is not to do anything. I will either admit everything or dismiss everything. I won't do anything. I won't pass any orders because I get into trouble. He says, judges frequently receive hostile or threatening correspondence from disappointed litigant. Creation of new disciplinary scheme will transform a minor annoyance into a constant threat, because you need to investigate every letter. Let's say a litigant is brave enough to put his name under. Then you need to investigate, you need to call the judge, and the judge may not remember even what happened and why did he write this judgment. He says, suggested that peer pressure will be the best effect on an erring judge. So if a judge is guilty of bad behavior, then other judges around him should come over and tell him very, very informally that, look, what you're doing is bringing the court into ridicule. People are talking behind your back. Do this. Some brotherly advice by the Chief Justice and others. Peer pressure is a potent tool. It need not be underestimated just because it is neither exposed to public view nor encoded in the law. I don't know how much it will work to somebody who is determined to close his eyes, or somebody who genuinely believes that he is in the right. I will give you an example. I was there in the court on all these odd occasions. There was a lady lawyer arguing very aggressively. She had a good point she was arguing. The judge stopped and said, look, it is 11 o'clock in the morning. You are killing me. You should be at home preparing food for your husband. What is your husband doing? Poor child. This is what he said in open court. There was silence. After 3 seconds, this young lady lawyer blasted the judge. Simply blasted. And the poor man didn't know how to react because it was for an earlier generation. His wife used to do it, and he thought that was genuine. And he said, I will take this matter away from me, and she will not appear before me. She said, that's exactly what I hoped you will do. Thank you. And she walked off. Case never came up before him. Nobody could correct this judge. And when he retired, the only punishment was the Supreme Court refused to make him senior. That was all. The correction didn't happen. The bad behavior continued. It was genuine. It was not vindictive. That's the only thing I can say in favor, but peer pressure didn't work. So after this 1995 Chief Justice of Bombay, the court noticed a gap between proved misbehavior and bad conduct inconsistent with high office. What do you do with bad conduct inconsistent with the high office? They said, taking a look at peer pressure, the Chief Justice or a High Court or CJI should have an in-house procedure. This in-house procedure will fill the constitutional gap and yield salutary effect. Then this in-house procedure came in. In furtherance of the directions in Ravichandran Iyer's case, the Supreme Court constituted a committee of 3 judges of the Supreme Court, Justices Agarwal, Justice A.S. Anand, then as a puisne judge, and Justice S.P. Barucha, and 2 senior-most Chief Justices, Justice P.S. Mishra and Justice D.P. Mohapatra, Andhra Pradesh and Allahabad High Court, and they formed this in-house procedure. In-house procedure is under 2 categories: complaints against Supreme Court judge, complaints about the High Court judge. Paucity of time, I will have the High Court judge alone now. First complaint is received against the High Court judge by CJI, by President, whoever receives it, forwarded to CJI or forwarded to CJ of the High Court. He looks through it. If it's worthless, frivolous, file it. Do nothing. But don't destroy it, file it. If CJI gets the complaint, he feels there's something worthwhile, he refers it to the CJ of the High Court, which is what has recently happened. And the CJ of the High Court looks at it and he refers it to the judge in question, saying, look, I've got this complaint, what is your reaction? All this is very confidential. And the judge gives back his explanation, not bound to do so, he gives back his explanation. Seeing the explanation, says there's something more to be done. Then there is a committee constituted. He says deeper probe is required. Then the deeper probe is, after considering the complaint in the light of the response of the judge and the comments of the Chief Justice of the High Court, CJI, if he is in opinion that a deeper probe is required, he will constitute a team-member committee consisting of 2 Chief Justices other than the High Court to which the judge belongs and 1 High Court judge. They will hold an inquiry. Inquiry will be in the nature of a fact-finding inquiry wherein the judge concerned will be entitled to appear and have his say. But it would not be a formal judicial inquiry involving the examination and cross-examination of witnesses and representation by lawyers. For conducting the inquiry, the committee will devise its own procedure consistent with the principles of natural justice. This was in 1999. But surprisingly, the in-house procedure was never made public until, I think, 6 years later, 2015. 2015, it was made public. Now, meanwhile, against one of the judges, there was a committee, and Ms. Indira Jaisingh filed a petition saying, please disclose this, what happened to the committee. 2003, 5 SCC 494, Indira Jaisingh versus Supreme Court of India. And the Supreme Court said, I'm reading the head note, we cannot direct any independent agency to inquire into the conduct of a High Court judge and release the inquiry report. There is no machinery to enforce the code of conduct of judges. Committee, being a part of the in-house procedure, cannot be approached for publication of the inquiry report. Right to information is not absolute. And they also say it is purely preliminary in nature, ad hoc and not final. If the Chief Justice of India is satisfied that no further action is called for in the matter, the proceeding is closed. If further action is to be taken as indicated in the in-house procedure itself, the Chief Justice of India may take further steps as he thinks fit. Therefore, in the hierarchy of the courts, the Supreme Court does not have disciplinary control over the High Court judges, much less the CJI has any disciplinary control over any judge. The position in law is clear. The only source of authority of CJI is moral or ethical, not under exercise of provisions under any law. Exercise of CJI's powers based on moral authority cannot be subject matter of a writ petition to disclose a report made to him. You might feel, why not disclose the report? Because if the report is rejected, we need to know why it was rejected. If it has been allowed, we surely need to know what is happening. The other thing is, don't embarrass a judge, because the presumption of innocence, which is true for every litigant, is 10 times more for a High Court judge or a Supreme Court judge. So this is the balance of in-house procedure. Then you have 2003, Justice the Indira Jaisingh's matter, and then 2008, proceedings against Justice Soumitra Sen. Soumitra Sen, the committee was Justice A.P. Shah, Chief Justice, Madras High Court, A.K. Patnaik, Chief Justice, Madhya Pradesh High Court, and R.M. Lodha, Judge, Rajasthan High Court. The committee followed this procedure, and the judge responded. They conducted the inquiry. The committee said, I am of the opinion misconduct so disclosed is serious, it calls for initiation of proceedings for his removal. Copy of the report was sent to Justice Soumitra Sen, and he was advised to resign, seek voluntary retirement, either way. But here you see, the chance is voluntary retirement, resignation, but not punishment, no punishment at all. Even impeachment by removal, it only means the person ceases to be a judge. It doesn't account for whatever has happened before. If I've got $75,000 for writing my book, I keep it. Nothing happens. That is one thing. Then after, I'm coming back to Justice Soumitra Sen. He said he won't resign at that point of time, and then proceedings were sent by CJI to the Prime Minister of India. The report was sent, and after that he wanted one more audience with the Chief Justice. Then the Chief Justice gave him one more audience with the collegium judges. But there was a further hearing. That was really not required in the House procedure, but it was given. Even after that, he did not resign. And then it went on, and then he resigned. The whole thing became infructuous. A third thing happened. So here what we are saying is, the pressure is so great, impeachment proceedings, that a judge resigns. But if a judge does not resign, he sticks to the guns, I will not resign, then what happens? Now, Justice V. Ramaswamy, I know him personally. I've appeared before him as a very young lawyer, puisne judge of Madras High Court, brilliant man. And very late in life, a few years before he passed away, I had the privilege of appearing before him as an advocate. At 92, his brain was so sharp. I had great regard for him. And then there is also this proverb, the Roman proverb, de moritus nil nisi bonum, which means of dead, don't talk anything but good, because they're not there to defend themselves. I'm not going into his conduct at all. I'm only saying he did not resign, and the impeachment proceedings were defeated. If that was defeated, does it mean his conduct is very rosy? We do not know. It only means he could not be impeached. There is no finding that he did not commit a misconduct. The finding. So what unfortunately happens is, if the judge is innocent, dismissal of the impeachment proceedings still doesn't remove the stigma from him. Then the other thing is, I take a very extreme case. There was this Irish judge in the Republic of Ireland, not the judge who was removed by English court, English impeachment proceedings. There was some investigation going on. The police came over to his house. He said, we'd like to check your computer. He said, no problem. Invited them over, checked the computer. they found he was subscribing to a child pornography site. And there were child pornography images downloaded in his computer. Very, very serious. And it was flashed all over in the newspapers. And the judge consulted his friend. He said, look, what's happened? I innocently left them in. And the barrister friend said, entry was without a search warrant. You just let him into the house. You didn't allow. He went and searched your computer. So the evidence collected without search warrant cannot be used. So the next time the police come over, deny them. Police came over, he said, I won't listen. They came with a warrant. By the time they came with the warrant, he cleaned up his computer. That evidence was not there. The furor was so much. But with this evidence, cleaned up evidence and circumstantial evidence, and the witness was only oral evidence against the judge's word, the Irish government said we can't initiate impeachment proceedings. He was not allotted any judicial work. So for about 3 years, 4 years, he was happy doing gardening at home, and he retired with a good pension. Is this justifiable? I'm pointing out these things to say these are the lacuna. It is like bringing a huge missile and to destroy what? A small little animal, and the house is destroyed, so we don't use it at all. And each time an impeachment proceeding is instituted, public aren't actually very fond of judges or lawyers. They're not very popular. And when all these news items are flashed, the system still comes down. Again, I'm quoting a Supreme Court judge. I'm quoting only retired judges, not sitting judges. He told me in the 1980s, when he and I became lawyers, there were 1 or 2 judges whose conduct was so and so, but nobody believed them. He says, today there are so many judges whose conduct is upright, but nobody believes they are upright. The whole thing, and how are we going to? So having impeachment proceedings is really not the solution. We need some via media. And look at what happens. The first punishment, the default punishment, whenever something is found wrong, something fishy, not proved, something is found wrong, you transfer the judge. When you transfer the judge, you're doing injustice to the judge because you're transferring him under a cloud without a finding against him. So you're doing the person, the judge, injustice. Second thing is, you're doing the court to which he is transferred injustice. I think every court to whom such judges are transferred, the bar immediately passes a resolution saying, condemning the transfers. Basic thing is, we want good imports. We don't want reject imports. So who is right? I think you can't transfer a judge until you get a finding that he is bad. If it's bad and misconduct, impeach him. Impeachment fails, give him work in your same court, because ultimately what is happening is you're paying him salary, you're paying him pension, and that's all coming from the common man's pocket, from all our pockets. So it should be black and white, it cannot be grey under the impeachment process. I'll go a little more deep into the 7-step process of the in-house committee. There are 7 steps there. Very coincidentally, Saptapati here also. First, complaint received. Second, Chief Justice entertains the High Court. Chief Justice means CJI or CJI High Court. Entertains. Nothing done, file. Something more, seek response from the judge. Again, you have a decision tree, it says, again you are satisfied with the judge's response, file it. Nothing more. Step 3. Do something more. Requires a deeper probe, then High Court's Chief Justice might consult, write to the CJI, get his opinion. Both of them feel, look, there must be a deeper probe, then the 3 judges come in, the committee come in. The 3-judge committee comes to a finding. That is just a stop there. If the 3-judge committee comes to a finding that there is misconduct warranting impeachment, then what happens? Then if the three-judge committee comes to a conclusion that there is no act warranting, then what happens? Now, one of the recent past cases was of sexual misconduct against the Chief Justice of India. Committee was appointed with lady judges also because of the nature of the complaint there. The complainant asked for in-house representation by a lawyer. In-house representation with a lawyer was refused because the procedure does not contemplate it. She protested. She said, I'm a lower staff here and you are three judges and you're discussing the senior most judge's case. How can I bravely present my case? I don't have the eloquence to do that. Please appoint. Judges said no. She said, if you're not giving me this basic thing, I'm walking out. So that was closed. And the report given, there is no finding. Is that justiciable? Is it justiciable? I don't know. But then there is another thing. Following step 2, step 3, in one of the cases, there was a 2-judges committee appointed by the Chief Justice of the High Court. He said it was a step in the progress. I don't want a 3-judge committee taking it to impeachment. Have a 2-judge committee. This was allegations of sexual harassment by Edin to enforce a moral authority or ask a report. But that is the authority of the Chief Justice probably, but the procedure has to be followed and you can't deviate from it. Then these, I'm coming back to the 7 steps. I'm quickly, how much time do we have? So this is the portion of it. I'm coming back to last week's judgment, 7th of August 2025. Justice Deepankara Datta bench delivered this judgment. This was a challenge to the recent committee report. And the challenge was issue an appropriate writ order declaring the misconduct warranting removal and the initiation to the Prime Minister, President, etc. ultra-virus unconstitutional. Removal as press release, removal, etc. unconstitutional. Quash and set aside the final report. These were the very detailed order was passed saying in-house, and the judge wrote very, I don't know if he intended it with the humor. He said the in-house procedure cannot be impeached. You have to follow the procedure. Judges can be impeached, in-house procedure cannot. And the material gathered, the trigger to these proceedings, all these are not justiciable. They are only preliminary findings, they are not binding. Everything has to be done de novo by the impeachment committee. They cannot rely on it. If they rely on it, they must give cross-examination, other things. So anything that we have read so far will expose the inadequacies of this. And what is the solution? Various solutions can be there, but my suggestion is you have a solution which is already in place but in a different form. You have this NJAC, National Judicial Appointment Committee. I would suggest you have an NJADC, National Judicial Appointments and Disciplinary Committee. That will solve issues because you have so many problems here. Now, what happens if the chairman and the speaker of the Rajya Sabha, Lok Sabha are in cahoots with this judge and they refuse to admit the impeachment motion? What happens if all the MPs say we have better problems, we won't file an impeachment at all? So many things are there. All this will be solved by NJADC, and other courts have such. England has and US has that. So thank you for that. I could have taken a little more time, but we are running out of time. So thank you with this. I'll take questions, but yeah. Yes.
But here natural justice.
No, a little bit after that.
Thank you very much, sir.
You
We are
again
so
for
busy
waiting.
schedule, but still you made out everything explain. I mean, and foreign countries and other things, judicial appointment, kings and other things, the way it is
Thank
done.
you.
Thank you very much. I give a huge claps to sir.
I should in turn give my clap to you for waiting all the time.
I request Rahul Agarwal give a vote of thanks. Sir. Rahul, please. Sir.
Thank you, sir, for giving me this opportunity. Sir, you have beautifully, taken us through the impeachment process, and it's a very fascinating topic as well. Impeachment of judges, short foreign suggestions. You taken us from the very beginning how the law evolved, the provisions, the articles like 124(4) for removal for the Supreme Court judges and 217 for the removal of the High Court judges. And you have also, to the lecture, you have told us the lacunas, there are various lacunas in that, and your suggestion to form an NGATC is really appreciable. And so thank you, sir. I won't take much of almost time. It's almost we are late. Thank you, sir. Thank you,
Yeah.
sir, for giving this opportunity.
Sir, we'll take your autograph, then we'll come to questions.
Yes.
Any message?
Here, they are no longer recording, are they? Questions?
No, sir.